The other interesting thing about this is this ruling was challenged below by both liberals and conservatives, by the governor of California and by the states of Montana and Alabama. They all attempted to overturn this with the idea of retaining control to address homelessness in their communities. The Supreme Court agreed.
Yeah, so this is interesting, Scott, because, and I know that the court doesn't deal with what would become now a city or a local problem, right? So the city does have the ability to enforce this anti-camping rule. They can remove homeless people. The Supreme Court says you are not punishing them for the simple act of being homeless, being without a place to stay, without a shelter. But now, of course, what do you do with people that you're removing from various public areas? That's something the court is not addressing. But perhaps was there something mentioned in the dissent?
Well, the dissent was very strong in opposing this, and saying, you know, you cannot criminalize a person essentially for the status of being homeless when they have no place to go. So essentially, you're arresting someone for their status of being homeless when they have no place to go, when the city or community has not provided a place for them to go. And so they're saying this does violate the Eighth Amendment. These people don't have a choice, and then you're turning them into criminals. But the Supreme Court took a different view. They're essentially saying, well, the policy on this, the power and authority should reside with the community to determine this. So one shouldn't interpret this opinion to mean that communities are going to go in and start arresting and putting people in jail necessarily. And that's why both progressive liberals, such as the governor of California, as well as conservative states such as Alabama and Montana, challenged this ruling because they want the authority and the power to deal with the homelessness, which at times may mean coming in, doing sweeps, criminalizing people who stay there in violation of their community regulations. So this will import a big change in the way communities can deal with homelessness.
All right. And Scott, real quick, in just 30 seconds, how does then the Supreme Court, when we think about cruel and unusual, there perhaps will be some Americans who will see this ruling and say, this does sound to my non-legal ears like it's cruel and unusual punishment. What did the majority say?
The majority says essentially, and I think it's encapsulated with the phrase of the opinion, which is says essentially, look, the Eighth Amendment doesn't wrestle the policy and the authority to deal with homelessness away from a community. The Eighth Amendment doesn't control policy here. Communities do control. And that's essentially what it's saying.
All right. Scott Frederickson, always great to have you, my friend, breaking it down for us. Appreciate you. All right, we've got some breaking news coming into the CBS News Broadcast Center. This out of Iowa. The state Supreme Court has announced it will allow the enforcement of the state's 6-week abortion ban. Now, the procedure remains legal in some states that border Iowa, including Illinois and Minnesota. Other nearby states, including Missouri and South Dakota, have banned abortion in almost all circumstances. We'll continue following that story and bring you some more updates as we get them here in the newsroom. But for now, former police chief Pete Arredondo has been released from jail. He, you will remember, has been charged for his role in the response to the 2022 Robb Elementary School mass shootings. The gunman there killed 19 children and 2 staff members. CBS News correspondent Janet Shamlian has been following this story almost from the beginning. She joins me now to break down what the Uvalde citizens are saying about this. So, Janet, how are residents reacting to the news?
Good morning, Vlad. Well, you know what? I just talked to Brett Cross, who lost his 10-year-old son in the shooting in Uvalde 2 years ago. And while he said this is a measure of accountability, and he was glad for that, these first criminal charges, he says it does not go far enough. Now, we are learning that another police officer, Adrian Gonzalez, may be charged, but that indictment has not been unsealed at this time. Talking to Brett Cross, he says, you know, we knew close to 400 officers were involved in this response. He wants to see more officers indicted. And we just got our hands on the 30-page, 10-count indictment for Pete Arredondo. These are felony charges of endangering a child. He turned himself in yesterday. He was released on bail yesterday. These are very serious charges. And for this community, it's been too long coming. I mean, you can imagine their grief. more than 2 years after this happened. But they're happy to see this. They want to see more. And for these families, they will really, there's nothing that can really ever make them happy, as we all understand. But this grand jury has been meeting since March and just came back with these indictments. So we're waiting to see, will the other shoe drop? Will there be more from here in Uvalde? Vlad.
Janet, just for our viewers who are just tuning in, the news that Pete Arredondo has been charged for the response to the 22 mass shooting there at Robb Elementary in Uvalde. Just take us back to that horrific day, one of the most horrific days of violence in American history. What happened and what we all saw ultimately from those security cameras, from the body cam footage of police officers who were responding to the threat of this gunman.
And I was here that day. We were working on a story in Austin, and within a couple of hours, the team that I'm with here now arrived here to an unimaginable scene. An 18-year-old came in, apparently made his way in through an unlocked door, and started firing at fourth graders and their teachers. And the response at one point reached close to 400 officers. Parents were held at bay, and what numerous investigations have since showed is that Pete Arredondo and other officers who responded did not do anything to end this siege. They negotiated instead of trying to break their way in. They didn't provide keys. They didn't enforce a plan. They basically just covered themselves and waited. And as a result, we lost 19 children and 2 teachers. It's still hard to say those numbers because if you have a child, as I know you're a new dad, Vlad, and I have 5 children, there's no getting over that ever. So there were multiple investigations, and all of them basically found, these responding agencies culpable. But this is the first time for criminal charges.
Yeah, and I'm hoping that the parents who've been demanding justice from the very beginning start to see some of that accountability. But you're right, Janet, when you see, we just put up the pictures of those 19 souls. And even in this moment, even after all this time, and I wasn't there like you were there on the ground reporting from it, a lump comes into my throat. Thank you very much, Janet. Appreciate it as always. Appreciate you.
It's horrific. Thank you.
It was indeed. All right, an extraordinary move from the state of Oklahoma requiring all public schools to teach from the Bible. But the new mandate is already facing challenges. We're going to tell you about it. You're streaming CBS News 24/7.
On our places, bright, shiny faces.
When you wake up in the morning, we want to be your go-to team.
Nate has one of the quickest minds I've ever seen.
Tony has a way of making people feel comfortable.
Gail has this unbelievable knack to ask the question that you're asking at home.
I've been told I could talk to a tree, and that's pretty much true.
I don't go to work in the morning. I go for coffee with my 2 good friends, and we talk about the world.
Your morning routine just got better. CBS Mornings, weekdays at 7.
It didn't seem like anything could happen, because nothing ever happens in East Palestine, but it did.
Authorities released toxic fumes from 5 derailed train cars.
Resident, please evacuate.
Acute bronchitis due to chemical fumes.
Did you ever have these problems before the derailment?
No, ma'am.
This neighborhood's not safe no more.
We can assure the community that there's not vinyl chloride entering their communities.
Then why are there so many people feeling these various symptoms of bloody noses or difficulty breathing, bronchitis?
That's a hard question to answer.
We're talking about one of the most blatant releases of a mixture of some of the most toxic chemicals that we've seen in America.
I feel like now I have a duty to warn other communities. If my daughter has to watch me die of cancer, at least it saves someone else.
This case.
It's like a screenplay, something straight out of Hollywood.
But it's not fiction. It's 48 hours.
Human remains found this week.
4 families shattered.
There's no physical evidence.
The mystery would haunt investigators for years.
There's some questions that have to be asked and need to be answered.
Like a John Grisham novel.
A gripping true crime original. 48 hours. Now streaming on the free CBS News app.
Stories that inform.
You can be really old at 60, and you can be really young at 85.
Inspire.
How do we unlock the power within ourselves to be who we want to be?
And brighten your day.
The best part of fame is making people feel good. Always send the people home happy.
Make every day a little more like Sunday morning.
Here comes the sun.
Stream now on the free CBS News app.
Hello, everyone, and welcome to our Dragon capsule here in space.
Sightseers in space, the thrill of a lifetime.
Seeing the Earth from space, it was so exhilarating.
But the risks that come with the territory.
There have been 4 fatal accidents. That's a 1% fatal accident rate.
Might make you look before you launch.
If you had 1 out of 100 airplanes falling out of the sky, we'd have a public crisis.
Space tourism, now streaming on the free CBS News app.
All right, welcome back to CBS News 24/7. Here's a look at some of the other top stories we are watching right now. Oklahoma's superintendent issued a memo requiring all public schools to teach from the Bible, including the 10 Commandments. It is unclear if he has the authority to mandate that. Civil rights groups are already slamming it, calling it unconstitutional and an abuse of power, and they plan to challenge it in court. A federal jury has ordered the NFL to pay nearly $5 billion in damages after ruling it violated antitrust laws. The case centered around the league's Sunday ticket subscription service that aired out-of-market games only on DirecTV. The NFL said it plans to appeal the verdict. Although he was excluded from last night's presidential debate, presidential candidate Robert F. Kennedy Jr. held his own one-man debate. It was streamed on X and on the RealDebate.com. He responded in real time to exchanges between President Biden and former President Trump. RFK Jr. wasn't on CNN's debate stage because he did not meet the polling threshold. Okay, let's take you back now to the Supreme Court, where we are already getting in some rulings, and we are expecting some rulings on controversial cases. This morning, they did rule on one case involving homelessness and loitering laws that came down earlier this morning, and another one just came in. The Supreme Court has overturned a landmark 40-year-old decision that gave federal agencies broad regulatory power. Still on the docket, cases involving Donald Trump's presidential immunity claims and a case dealing with the federal obstruction charge used against hundreds of January 6th rioters. Defense attorney and former federal prosecutor Scott Frederickson rejoins me now to talk about this. So, Scott, let's talk about that ruling that just came in. And we talked a little bit about this yesterday when we were talking about the EPA decision. What about this case? And you sort of previewed what we were going to see this time around.
Yeah. Well, this is a momentous decision, one that may not have a high profile like the immunity decision. But this case takes a sledgehammer to the power of federal agencies to interpret and administer the regulations that they're charged with enforcing. That may be the EPA, that could be the Labor Department, all the different agencies. What we're talking about here is what's called the Chevron doctrine. It dates back 40 years, and basically it said, look, when a federal agency is enforcing and administering a law of Congress and there's some ambiguity, courts have to defer to the agency that enforces that regulation for its interpretation of that regulation. This Chevron doctrine has been under attack by conservatives now for the last couple of decades. And today, the Supreme Court sided with conservatives. This removes a huge amount of power of federal agencies in their enforcement of the laws that they are responsible for. So this means we're going to see a huge rollback, lots of litigation about the different federal agencies in their enforcement of regulations.
All right, Scott Frederickson breaking it down for us. A monumental decision, perhaps not one as high profile as the last couple ones that we're expecting, but still an important one for people who those regulatory agencies were in fact set up to protect. And I think that that's the real issue here. I know that we talked about yesterday the federal government and many conservatives feeling that the federal government had too much power and perhaps had overreached in some of those cases. But again, a lot of these agencies were set up in the wake of really terrible things that happened. Either we're talking about the SEC, where people suffered through the Great Depression, or what we were seeing in the late 1950s and 60s in terms of the environment when the EPA was set up.
Well, you're 100% right, Vlad. I think we're really going to see that in the area of the EPA, having to do with water pollution, air pollution. You know, people forget that back in the 70s, 60s and 70s, you know, our rivers were on fire. You couldn't see our cities because of smog. A huge reason that all got cleaned up were the laws that Congress passed and the regulations the EPA enforced. Now, the conservatives said, you've gone too far, though. The agencies are basically a power unto themselves. In this case, we had a New Jersey commercial fisherman who was required to take a monitor of the federal agency involved in fisheries along when he was out fishing. They didn't challenge the fact of having a monitor, but the agency said, and you have to pay them $700 a day. And that's what was challenged. And so conservatives said, look, that's not what the statute says. That's up to Congress, or at least the courts, to decide. Regardless, we're going to see a huge rollback of what the agencies have been able to achieve. And, you know, the EPA is probably the best example of what's going to change now in this country.
All right, Scott Frederickson, thank you, my friend. Appreciate you. CBS News campaign reporter and attorney Katrina Kaufman is standing outside of the Supreme Court. All right, Katrina, we've still got two other cases that we're waiting on. And of course, if those cases come in, we're going to have a special report anchored by Nora O'Donnell. But describe to our viewers what they are and what is at stake here.
The biggest case that we are watching out for is the one involving presidential immunity. And this was brought by former President Donald Trump, who claims that presidents have immunity from criminal prosecution for their official acts. The court will be making a determination about whether or not the president has immunity and potentially distinguishing between private acts and what counts as official acts. The short-term implication for this will be for the very important D.C. election interference case against Trump, and whether, when, and how it can move forward before the November election, if it can, because of course, if Trump is elected as the next president, he could get that case dismissed altogether. The other case that relates back to the DC election interference trial as well is Fisher. This is related to the January 6th Capitol riot. It was brought by one of the rioters, Joseph Fisher, a former police officer, who says that a statute that was brought against him related to the obstruction of an official proceeding doesn't apply to the January 6th Capitol riot. It's always been used related to documents and records, and this also involves two of the charges against Trump in the DC election interference case. So it could impact the shape of that case as it moves forward, depending on how the Supreme Court rules on this.
All right, all eyes on SCOTUS, even at this late hour. All right, Katrina, thank you very much. We'll check back in with you if those decisions come in. Thank you.
Thank you.
Iranians headed to the polls today to vote for their next president after former President Ibrahim Raisi died in a helicopter crash back in May. Our Elizabeth Palmer has more from Tehran.
The polls are now open across Iran, with 61 million people eligible to vote in what appears to be a very tight race. The frontrunners include two hardliners, the former mayor of Tehran, Mohammad Bagher Ghalibaf, and the ex-top nuclear negotiator, Saeed Jalili. It is just possible that these two could split the vote, which would allow the only moderate who was allowed to run, MP and heart surgeon Mansour Pezeshkian, to emerge with a strong showing. He's on record as supporting better relations with the West, which of course includes the United States. If, as is quite possible, no one candidate gets a clear majority, the race will go to a runoff in a week. We should get some idea with preliminary results as early as Saturday morning. Elizabeth Palmer, CBS News, Tehran.
All right, Liz, thanks so much. Right now, the jury in Karen Read's murder trial is deliberating for a fourth day. Penny Commit from our CBS Boston station has been following the case. Penny, you've been on this from the beginning. Just take us back. How are those involved with the case and Read's supporters, which I saw your report the other day. I mean, you've had people coming in from all around the United States to follow along in person at this trial.
Vlad, there was a little kid today that was from Tennessee with his parents. That's how much people want to be right here for the verdict. You know, this is a polarizing trial. I've been on this for 2 months, and just every day it gets more and more polarizing. People tell me they've lost friends and family over this trial, and especially because people really have their preformed beliefs before we even entered the courtroom 2 months ago. So to a lot of people, they think, you know, this is an obvious answer no matter what side of the aisle you're on. But there have been so much evidence presented in this case, over 600 pieces of evidence, 74 witnesses. This trial spanned over 2 months. So if the jury is really doing their job and being impartial like they say they are, of course it's going to take a few days, especially because both sides in this case presented two totally different theories as to what happened. The prosecution saying that Karen Read hit her Boston police officer with her car, left him to die in the snow. And then her attorneys say that actually 2 other Boston police officers killed him, and Karen Read is part of this elaborate police cover-up. So the 2 pictures painted here could not be more different. The jurors have a big decision to make. And the growing fear, especially among some of our legal analysts we've been speaking to here in Boston, is that it might be a hung jury. And I can tell you, that would just be so devastating for this community. It's so polarizing. People are so passionate about this case. At least if we have a decision, we could get some closure. But listen, we're on track. Some other major trials in Massachusetts that have gone about 2 months, they took 5 or 6 days to deliberate. So 4, I think we're still on track to hopefully get a decision maybe today or early next week.
Yeah, Penny, I know you've been covering this, and it's striking to me to see people and see the attorneys coming in and they're high-fiving supporters of Karen Read. And all I keep thinking about, we showed a video of a woman holding up a sign, "Justice for Officer O'Keefe." There is somebody who did lose their life, and sometimes it feels like the people that are looking at this like it's a movie or something lose sight of that. But you've been doing some incredible reporting on the ground there. We appreciate you. We're going to check in with you, Penny, if we do get a verdict. So I know you'll be sticking around. Thank you very much.
Thanks, Vlad.
All right, as I told you, if we do get a verdict, we're going to bring you coverage from CBS News Boston. It's happening right behind us here on the screen, and so we'll bring that to you live right here from CBS News. Now, this morning, the very first LGBTQ+ visitor center to be recognized by the National Park Service is opening its doors, and it is located, guess where? The iconic Stonewall Inn, where it all began back in the 1960s right here in New York City. We're going to take you there next. You're streaming CBS News 24/7.
Washington is the seat of power. National security, foreign policy, global economics, every story comes through Washington in some way. We bring some of the most powerful voices in America to the table. We don't just ask the questions, you have to go deeper. We try to understand what's at the heart of the issue we're talking about, to then come forward with solutions.
Face the Nation on CBS.
The justices ruled that Harvard and the University of North Carolina violated the Constitution.
In the aftermath of the Supreme Court decision to end affirmative action in college admissions, uncertainty sets in for some students of color.
Affirmative action really gave us an equal opportunity.
CBS Reports explores the historic decision and what it means for those chasing an opportunity to change their lives.
I knew that college was the ticket to break this cycle.
The end of affirmative action, now streaming on the free CBS News app.
Okay, let's go.
You guys good?
Hey.
All right, we good?
Keep going. The clock, it's ticking.
Off we go.
60 minutes. 60 minutes.
60 minutes.
It's time for 60 Minutes, Sundays on CBS.
An original documentary from CBS reports.
AI is among the most world-changing technologies ever.
Curing diseases, scientific breakthroughs, making lives better.
It can help us with medical discoveries, scientific discoveries, doing better agriculture, having cures for things like Alzheimer's.
It's also going to really transform the way we work.
The uplifting potential of artificial intelligence is limitless.
It gives you a friend, somebody to chat with 24/7 that is non-judgmental. He makes me feel loved and desired.
And so are its downfalls.
The problem with all this AI is that it's unpredictable and uncontrollable.
The choices we make now will have lasting effects for decades, maybe even centuries.
The ChatGPT revolution, now streaming on the free CBS News app.
We are about to see American weapons in the hands of Mexican cartels.
A gun pipeline to Mexico.
We are arming the cartels.
100%, no doubt about it.
Happening right under our noses.
Who's doing something about this? Nobody.
A CBS Reports exclusive.
Most Americans have no idea that we are effectively arming the enemy next door.
This is the story the American people need to know.
Arming cartels, now streaming on the free CBS News app.
America Decides, taking you inside American democracy.
The most important stories on a day-to-day, hour-to-hour basis.
You're going to hear a lot of reporting.
It is clearly a pivotal moment.
Gun control, the economy, education.
Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News streaming.
Welcome to America Decides, Monday through Thursday at 5 p.m. Eastern.
A new visitor center opened right here in New York City, marking 55 years since the 1969 Stonewall riots. That event, June 28, 1969, helped spark the modern gay rights movement, and President Biden is expected to make a stop there later today. CBS News New York reporter Shosh Bedrosian is down at the center right now.
We are marking the end of Pride Month, and today politicians and celebrity advocates will be visiting the center for the very first time, which will be honoring the LGBTQ+ movement. Now, it's the first time a visiting center like this is being recognized by the National Park Service. The brand new 2,100 square feet visitor center on Christopher Street will serve as an educational resource and offer an immersive experience about the LGBTQ+ history through different kinds of programming. Founders of the center say the experience will encourage people to carry forward the Stonewall legacy and the ongoing fight for LGBTQ+ equality. Today marks 55 years since the Stonewall uprising, which was the beginning of a series of events between police and LGBTQ+ protesters for 6 days. The events of that week would spearhead the activism in the United States. For the whole month of June, New York City honors and celebrates Pride through a series of events. NYC Pride says the events are inspired to work towards a future without discrimination where all people have equal rights under the law. The annual NYC Pride March will be on this Sunday, June 30th, which originally started back in 1970, just 1 year after the Stonewall uprising. The Pride March will be taking place right here along 5th Avenue. For a full list of Pride events, you can head to our website. As for the visiting center, it is officially open for the very first time today to the public and is free of charge. In Midtown, I'm Shosh Bedrosian, CBS 2 News.
All right, Shosh Bedrosian, thank you very much. All right, we just have now into the newsroom a monumental decision from the Supreme Court of the United States. That decision that we were awaiting, which we're still getting. Eric, my executive producer in the control room, just told me that the decision came in. Eric, but we don't know yet, or at least we don't have, I don't have it printed or in my hand what that decision is, but we're told that that is coming imminently. Still waiting. So we've got a team of reporters, including Katrina Kaufman, our legal analyst, Scott Frederickson, who's going to join us. Scott, if you're there, this decision, people were waiting for it. And I should tell our viewers, look, we are expecting that there will be a special report, a CBS News special report that will be anchored by Norah O'Donnell here in New York City. So we may cut away to that, Scott. But while we have you, tell me what the court ruled.
Well, I wish I had the ruling, but I don't have it yet. Haven't seen it. I haven't seen the opinion yet. So we're still waiting.
All right, Scott. So let's start here. What was the court deciding?
We're talking about the January 6th case.
January 6th. Yeah. What was that? What was the case about?
Well, the January 6th case is about whether or not former President Trump is entitled to immunity for the actions he took while in office in connection with attempting to overthrow the election. And the arguments are whether he is fully immune, in which case he can't be prosecuted, or as the lower courts held, that he's entitled to no immunity, in which case it goes right back to the district court, and he conceivably, maybe unlikely, but conceivably could be in front of a jury before the election for a criminal trial.
So the former president has argued that he can't be subject, Scott, to criminal prosecution for official acts unless he's first impeached in the House and convicted by the Senate for that reason.
Well, that's right. And I don't think the Supreme Court, and certainly not the lower courts, credit that very much. The Supreme Court, however, seemed to go off on the issue of trying to separate out official acts of the president, for which some of the conservative justices think there should be immunity for official acts, and purely private acts, say in connection with his the election of 2020, in which case he would not be entitled to immunity. So we may
Scott, let me
see
just interrupt you for just a moment here, because we do now have what that ruling, and this one has to do actually with the official proceedings, the obstruction of an official proceeding. The court holds that to prove a violation of the law, the government must show that the defendant is impaired. All right, let's go to the CBS News special report right now.
This is a CBS News special report. I'm Norah O'Donnell. We are coming on the air with breaking news from the Supreme Court, where the justices have just ruled on a case that could impact the prosecutions of hundreds of January 6 cases, as well as the special counsel case against former President Trump. The question before the court was whether prosecutors can apply a law passed in the wake of the Enron scandal to those who breached the Capitol. Former President Trump was also charged with 2 counts of obstruction for his alleged attempt to overturn the 2020 election results. The law, as written, makes it a crime to corruptly obstruct or impede an official proceeding. Now, defense attorneys argue that the Department of Justice has turned the law into a dragnet. Before the attack on the Capitol, federal prosecutors had never used the statute in cases that did not involve evidence tampering. Let's bring in CBS News chief legal correspondent Jan Crawford. I know you just started reading the ruling. How did the justices rule?
Well, it was a vote of 6-3, a somewhat unusual lineup. The Chief Justice is writing this decision with some of the conservatives, but also joined by liberal Justice Ketanji Brown Jackson to vacate a lower court ruling that had allowed a broad interpretation of this obstruction statute, which, as you mentioned, was then applied to several hundred January 6 defendants, including one former President, Donald Trump. This charge represents the basis of 2 of the 4 charges against President Trump. So the question now is, because the court is narrowing prosecutors' use of this statute, in what cases could it be applied? I think it's very important to point out that even with this decision, which is saying that prosecutors have been using this charge too broadly, they've got to narrow it, tie it to some destruction of evidence, which is in the clause right before the charge they've been using, that even with that, this does not mean that prosecutors can't charge all these January 6 defendants with obstruction of an official proceeding. It has to be tied to some kind of destruction or tampering with evidence or documents. But what was happening in January 6? What was happening in that Capitol? There was evidence. There were papers. There were certificates, state electoral votes. So I will be shocked if Special Counsel Jack Smith does not have court papers ready to say that he can still charge former President Trump with obstruction, arguing that he was trying to interfere with the counting and the counting of those state electoral votes, which were paper, which were evidence. The reason this case is important, and you pointed it out, is this is a Supreme Court that has been really concerned about prosecutorial overreach, that they're taking cases and charging people under criminal laws that Congress may never have intended. They're expanding the use of the criminal law in ways they shouldn't do. This is a court that has unanimously reversed convictions, for example, of the former Virginia governor governor who was charged under a bribery statute. And so it's consistent today with what they're doing, that prosecutors can't just look at a law and say, yeah, that would fit. They have to make sure that it works in the statute and what the laws that were before it, just preceding it, and also the purpose of the law. The purpose of this law, Congress passed Sarbanes-Oxley, the wake of the Enron accounting scandal. And this specific charge was to close a loophole that Enron auditors had been able to get off because they had shredded documents. And so this was in response to that, to address that kind of tampering of evidence, destruction of evidence. So today the court is just saying, you just got to look at that and make sure that is what's happening. So, 6-3, as I said, a big decision, a win for some of the January 6 defendants, certainly, but not necessarily a big win for former President Trump.
Jan Crawford, thank you. We should note this case is the first in which the Supreme Court has been tasked with tackling fallout from the January 6th insurrection at the U.S. Capitol. I want to bring in our chief Washington correspondent, Major Garrett, and to discuss the real-world implications. Sure. This involves a man named Joseph Fisher. He was a police officer in Pennsylvania. He attended that Stop the Steal rally outside the White House and later entered the Capitol around 3:25 on January 6th. Prosecutors said that he charged officers there. He was faced with assaulting a police officer, disorderly conduct, corruptly obstructing and influencing and impeding an official proceeding. That's what's at issue here. This is him inside the Capitol, this picture. And his attorneys said, no, you can't use that. That's too broad of a reading of that particular felony that was leveled against him. What happens now?
So the key word you just used there, Nora, is felony. This charge brought a potential jail sentence of 20 years. It was a point of leverage federal prosecutors used not only with Mr. Fisher, but others, either to win plea deals or to make them understand the consequences of their actions on January 6th. And Mr. Fisher's attorney said, is entering the Capitol, is disrupting the certification of electoral votes the same thing as destroying evidence, which is what the statute is specifically about. They argued it wasn't. The Supreme Court has now agreed with that. What's interesting about this moment, Nora, is right after January 6th, there was a momentary consensus in this country shared by a great number of Republicans who said the following: those who entered the Capitol, acted as rioters, should be prosecuted to the fullest extent of the law.
Those are Republicans who
said that momentarily. They've since backed away in large measure from that, but fullest extent of the law. That's the central question here. What is the fullest extent? Did Congress intend for someone who disrupted the peaceful transfer of power to be someone prosecuted for tampering with evidence? The Supreme Court said no. Those who defend the statute and the application of this law said this is a unique moment. Destabilizing the peaceful transfer of power in this country must have deterrence built around it.
It's such a unique occurrence.
And every tool that prosecutors can find should be used to legally deter people in the future. Because if we don't deter Americans from trying to block the peaceful transfer of power, do we still retain a constitutional republic?
The Solicitor General, in her arguments, the U.S. Solicitor General, tried to remind the justices of the unprecedented nature of the events on January 6th. I want to bring in congressional correspondent Scott McFarlane, who's been tracking all of these cases related to January 6th. I dare say there is no one who knows more about these defendants than Scott McFarlane. You just can follow him online. Let me ask you, what do you think this means?
It's going to have a limited impact on some of the defendants, including those who are in prison right now, Nora. The Department of Justice hasn't just used this charge in January 6 cases. They've used it frequently, and they have used it effectively. By our CBS News count, about 350 of the 1,400-plus January 6 defendants faced that charge, among others, obstruction of an official proceeding. As of today, roughly two-thirds of them still have that charge either on their record or pending. That's about 250 people. And that's going to include people who beat police officers. It will include those names you might remember, the Proud Boys, the Oath Keepers, those far-right groups. But there's a smaller subset, according to our CBS News review, of about 30 defendants for whom that's the only felony charge. Those cases include people who are in prison as we speak. Those prison sentences might have to get reviewed. You might ask yourself, what about all those other people who also face that obstruction? It certainly means they could be let out of jail early. In fact, Nora, according to our review of the court filings, some of the defendants who were convicted on that charge or pleaded guilty to that charge have had their prison sentences delayed or have received release early pending this decision because the judges recognize some of these prison sentences might need to get revisited if the Supreme Court did what it did today. But for all the others, those who were convicted of it, who pleaded guilty to it, who've already served their time, the Department of Justice sources with whom we're speaking don't think they're going to go back and try to reopen plea deals. That's a dangerous world. That man is worth noting. Kevin Seafried of Delaware, seen there famously parading the Confederate flag right past the U.S. Senate January 6th. He was released from prison early in late May, according to my review of the court filings, because he cited this argument. The Supreme Court review itself, among other things, he faced that obstruction charge, and the judge agreed to release him pending his appeals because they may have to recalibrate the prison sentences based on this decision. And one other note, we went through all the court filings and all the trials. All the federal judges in Washington, D.C. thought this appeal was offline, that it wasn't right, that it wasn't justified. But there was one judge, a judge named Carl Nichols, a Trump appointee, who bought into this appeal from Joseph Fisher, and began this trajectory towards today, where it gets to the U.S. Supreme Court. And one other note, Nora, I should add, there are so many defendants in this, the largest criminal prosecution in U.S. history, 1,400. Joseph Fisher is one of two Joseph Fishers, who are former police officers charged with January 6 crimes.
There is so much to digest, and the implications are potentially far-reaching. Scott McFarland, thank you for walking us through that. We should also note that this decision today by the Supreme Court could be used as fodder for claims by Trump and his Republican allies that the Justice Department has treated these Capitol riot defendants unfairly. We saw Donald Trump in the debate last night saying that some of these rioters were, quote, ushered in by the police. He even said some of them are, quote, so innocent, in his words, and, quote, peacefully patriotic. So the question is what will happen to these some 30 defendants who have been convicted on this charge, who are in jail that Scott just talked about. And then the other big question is, how does this affect Donald Trump himself? Let's bring in former Justice Department prosecutor Tom Dupree on that matter. Tom, what does the special counsel Jack Smith do now?
Well, I think what the special counsel needs to do is to look at the precise acts that he was planning to charge former President Trump with in connection with this claim and see whether or not he still can prosecute Trump on this charge, given the Supreme Court's decision. Look, the January 6th was obviously an extraordinary and a terrible day in our nation's history, but this Supreme Court decision is fairly straightforward. The court in recent years has taken the approach of construing criminal statutes literally, somewhat narrow. So in that respect, today's decision isn't a particular surprise. I think the task for the special counsel is to say, okay, the Supreme Court has spoken. It's told us what this law covers and what it doesn't cover. And so I need to go back, dust off the allegations, and see whether or not the facts and the evidence I have in my possession are sufficient to state a charge against former President Trump under this new standard.
Stand by, Tom Dupree. I want to bring in Jessica Levinson, our CBS News legal contributor. She's also a Loyola Law School professor. And Jessica, I know you have been reading the dissent here, an interesting coalition of justices on this. Tell us what you see.
I see Justice Barrett writing for two liberal justices herself and Justices Sotomayor and Kagan. And this is a pretty stinging dissent where she says, I'm looking at the statute, and why can't you accept that the statute is broad? Why can't you accept majority that or otherwise allows for the prosecution of people who walked into the Capitol on January 6th and engaged in a riot? Because she's saying, and this whole dissent is tied so so closely to the words of the statute. She says, or otherwise means you tried to corruptly impede a official proceeding, and a riot is enough to do that. It doesn't have to be tied to document destruction. She uses words like that the majority here is disingenuous, that they do textual backflips. And it's so interesting to see somebody who was appointed by former President Trump saying, give the prosecution credit, allow them to look at this statute. Congress meant this to be a broad grant of authority for them. And she obviously didn't win the day, but very interesting lineup, because I know the headline will be 6-3, but we really have to look at who makes up the majority and the dissent here.
Jessica, can I ask you about what the majority said? Because some of the concerns that were raised in the discussion about this case earlier, Justice Gorsuch, for instance, they said, well, what prevents using a broad interpretation of the statute when someone disrupts a Supreme Court proceeding or something like that? Why isn't that viewed as distinct from the certification of a presidential election? This was such a unique instance.
This is a unique instance. I think what the majority would respond is it's not our job to determine which type of official proceeding is important or different. It's our job to look at the words on the statute and say, what exactly does somebody who's charged under the statute need to do? And what the Supreme Court, what the majority is saying here is it can't just be walking in and engaging in a riot that stops either a Supreme Court proceeding or a city council meeting, or in this case, the counting of electoral college votes. It has to be tied to some sort of document destruction. So I think, and it's such a good question, I think what the Supreme Court is saying is it's not about how much we care about a Supreme Court proceeding or something so important. Let's remember, the certification of the electoral college votes is about the peaceful transfer of power. It's something we hold so dear. The court is saying today, we're not talking about the importance of that. We're talking about the words in the statute and how broadly or narrowly we can read them. It's the dissent that seems much more worried about the consequences here, in my mind.
Jessica Levinson, you explained this so well. I really want to be a student in one of your classes because I think I could go around about an hour with you on this. It's just so fascinating to me, and of course, such an important case, not only for the nation, but also those dozens of defendants who've been charged with this felony, and how this will affect the prosecution of Donald Trump. And on that matter, per our Rob Legary, who covers the Justice Department for CBS News, Jack Smith, who's the special counsel, is declining to comment on the Fisher ruling at this time, but no doubt we will probably hear more from him in the future. Once again, the breaking news from the Supreme Court: the justices have ruled 6-3 in favor of some of the January 6th rioters, limiting the use of these obstruction charges. It was a novel charge that's also been brought against former President Trump. It's an Enron-era obstruction charge, and so the justices want a more narrow reading of this particular law. We're also, we should note, awaiting a ruling from the Supreme Court on whether former President Trump has absolute or qualified immunity for conduct that allegedly involves his official acts during his time in office. That is expected to come as early as Monday, the last day of the term. Our coverage will continue on CBS News 24/7, your local news, and then tonight on the CBS Evening News. Thank you for joining us. This has been a CBS News Special Report. I'm Norah O'Donnell.
Hey everyone, I'm Vladimir GT. You've been watching a CBS News special report. That special report having to do with the Supreme Court justices that just ruled on a case that could have an impact on the prosecutions of hundreds of January 6 cases, as well as the special counsel case against former President Donald Trump. The justices chose to narrow the Justice Department's use of a federal obstruction statute leveled against scores of people who breached the Capitol building on January 6. Former President Trump was also charged with 2 counts of obstruction for his alleged attempt to overturn the 2020 election results. defense attorney and former federal prosecutor Scott Frederickson joins me now to talk about this. So, Scott, this was really interesting. This is a post-Enron federal obstruction statute that was implemented in the wake of that Enron case. You'll remember I worked on Wall Street back at the time. Enron was a devastating money loser for many, many Americans who had invested in that company, either through their 401k or individually. That law was put into place. And here's part of what the statute says, right, which is that whoever corruptly, and there's a bunch of stuff here that has to do with alters, destroys, or mutilates, or conceals a record or document. That's not what the court was dealing with. The court wanted to focus on whoever otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. That is what they were using in this particular case that the Supreme Court was deciding. You heard the analysis on the special report. What more can you add for context?
Well, this decision goes off on a fairly narrow statutory interpretation. This court, the majority, essentially saying, well, look at the first paragraph that you just referenced talks about destruction of documents. And so when it says otherwise corruptly obstructs proceedings, that must have to do with, documents and evidence. The dissent led by Amy Coney Barrett says that's not true. This is intentionally a broadly structured statute by Congress, but that did not carry the day. So here, the Supreme Court is again taking a position to really carefully retract the powers of prosecutors in their interpretation of statutes. So not a surprise based on oral arguments. We probably saw this coming. A significant impact on a minority of the January 6 rioters. The vast majority of them were charged with other violations, not just this one. And for President Trump, he was charged with 2 counts under this statute. This will go back, and the special counsel, Jack Smith, can decide to drop those counts. But he also has an argument to say, look, the president conspired with others to create false slates of electors, and that satisfies this statute, even under this very restrictive reading and ruling by the majority here. So more to be heard on that when that case eventually goes back to the district court.
Scott, let me just ask you before I let you go about the way that the decision came down. In other words, we see Amy Coney Barrett with the minority writing that dissent, and we see Associate Justice Ketanji Brown Jackson siding with the other conservative members of the court. I know it's impossible to get into the minds of these Supreme Court justices, but just help people understand in the world where we live in now, where everything is binary and everything is political and we feel more divided than ever, it is interesting to see a conservative justice siding with the liberals and a liberal justice siding with the conservatives.
Very interesting. And let me speculate why Ketanji Brown Jackson, Justice Jackson, sided with the conservatives. Her background, in addition to being a judge, before that, she was a federal public defender, well-respected one. And this would be that kind of position that a defense counsel would very much take, that, look, the government's overreaching. This is a broad interpretation of the statute, and that should not be allowed. And that's, I think, why she joined with the majority here. Meanwhile, Amy Coney Barrett, who's really, I think, carving out a real separate, independent space for herself this term. And this is a good example. She says, look, the plain meaning of the statute is to be broad. Why can't we read it that way? And frankly, I think she has the better argument.
All right, Scott Frederickson, thank you, my friend. Appreciate it.
My pleasure. Glad.
All right, let's go back to Katrina Kaufman, who is standing outside of the Supreme Court of the United States. Katrina, you heard the discussion that I was having with Scott. You heard the discussion at the CBS News special report. Very interesting ruling here.
This is a very interesting ruling, and one thing that Scott was saying really struck me related to how this could impact special counsel Jack Smith's case against former President Donald Trump. Because this narrows the scope of the obstruction charges, it doesn't mean that it necessarily strikes them from the indictment, because there are, in particular, these actions that Trump took related to the fake electors scheme that Scott was talking about. And that really falls within the scope of how the justices are defining this obstruction statute now. So Jack Smith is really going to have to take a look back at these obstruction charges, figure out whether he can move forward with them as they are, because they are very important to his case. They allow him to tell the story of the Capitol riot that took place on January 6th, of Trump's role in it, to have witnesses from that riot at the trial as well. So it's very, very important to the narrative that he wants to convey to a jury when this case goes to trial.
All right. Katrina Kaufman standing outside of the Supreme Court of the United States. Katrina, I'll probably be talking to you on Monday. Actually, I won't, because I'll be on vacation, but you'll be there, and we'll check in with you as a network later throughout the week as we await more decisions. Thanks, Katrina. Let's bring in CBS News Chief Legal Correspondent Jan Crawford, who's also with us from Washington. So, Jan, impressions. I was really intrigued. I know we've broken down this decision, and we've broken down the earlier decisions that came down this morning, but I'm intrigued by what Scott Frederickson was saying about what he called the path that Justice Amy Coney Barrett is carving out for herself at this term. What did you make of that, and of Associate Justice Ketanji Brown Jackson siding with the conservatives in this case?
Yeah, I mean, I agree with all of that. I mean, I think we're going to be seeing a lot of headlines at the end of the term on these think pieces where people are kind of saying, like, it's Justice Barrett's court, because she has shown a willingness to kind of go away from some of the positions that conservatives have taken and join with liberals, unusual alliances, or limit the reach of what some of the conservatives may want to do. On some of these cases, as Barrett goes, I think you're going to be able to say, so goes the court. Justice Jackson, also a fascinating figure to look. And, you know, when I think about when we talk about the court and what's the state of the court, you have to, it's like remember in the old days when we had those Polaroid pictures? You know, now I don't think we have.
I do remember
but, you know,
them.
It takes time. You know, it takes time. You shake it, but it takes time for those images to come into focus and clarity. And that's always true when you have new justices joining the court. How does that affect the dynamics of the court? Where do the justices go? And so we're starting to see that snapshot become more clear. And you're seeing great independence from Justice Barrett and also from Justice Jackson. I think her joining with the Chief Justice's opinion today is entirely consistent with what we would expect, as Scott said, from a former public defender. You might even think, like, this should have been the liberal position. You know, liberals used to, you would say, get really concerned about prosecutorial overreach and due process and taking criminal charges beyond what perhaps Congress intended. So you could say she's kind of being true to form there. But at any rate, I think it's going to be a fascinating term. And then, of course, we've got that big immunity decision. Monday will be the last day of the term, the big immunity decision that's going to be coming down on that day. So who knows what that lineup will be.
Jan, brilliant metaphor, the idea of the Polaroid picture. And for viewers of our broadcast who are familiar with what that was, and I think they even still have Polaroids out there, the idea that, you know, you're coming into focus as a justice, as an associate justice, is really interesting to think of.
It takes time. And already, I mean, look at some of the really interesting lineups, like even yesterday in the cases, some of the interesting lineups that we've seen already. A new justice, and when a new justice comes on the court, and Justice Jackson, of course, is the most recent one appointed by President Biden, that can cause other people to rethink their alliances, rethink their positions. It can have a big impact on the court. I think we're seeing that. And, of course, with the second most new justice, Justice Barrett. Today's opinion, just to reiterate, though, and get back to that, Vlad, this is, of course, a win for some of these January 6th defendants. But as you've been discussing, this is not necessarily a win for Donald Trump. And I want to raise one thing. There is an opinion, which I have in my hot little hands, from a judge in the D.C. Circuit here, the Federal Appeals Court here. She just wrote this in a totally different case that I think provides a real roadmap for Special Counsel Jack Smith to go forward with this obstruction charge against Trump. She talks about, like, if you can show, for example, that they're there to actually corruptly try to interfere with the looking of evidence, those state election certificates, the slate of electors, that you can still go forward with these charges. So I think he will have a strong argument that Trump, you know, had that kind of intent to interfere with the counting of those votes, unlike some of the other people who may have just gotten caught up in the mob and found themselves in the Capitol.
Yeah, it was argued during this trial or this session of the Supreme Court, Jan, that the former president was trying to obstruct the arrival of certificates arriving to the vice president's desk for counting, which is a thing, they argued, used in an official proceeding.
That's right.
Right. All right, Jan Crawford, always great to have your brilliant analysis and reporting. Thank you very much, and for sharing that new nugget for us and our viewers. We appreciate you.
Thanks. All
right, let's go to Scott McFarland. Scott has been covering January 6th from that very day, and he has followed the trials of those January 6th defendants. So the question, Scott, that I have, and I have not covered this in the way that you have, and I'm not a lawyer, but does this ruling mean that there are some of those January 6 folks who went to prison who are going to get out of jail now?
Oh, it sure does, Vlad. It's a matter of how many. Of the 1,400 or so January 6 defendants, yes, there have been that many, about 250 had that top-line felony of obstruction of an official proceeding. It was one of the felonies they faced. About 30 of them face the prospect of or are serving prison time with that being the only felony charge. So with the Supreme Court appearing to move backward on obstruction of an official proceeding, those 30 or so face the prospect of having their prison terms shortened or their prison terms ended. And that's important for several reasons, but not the least of which is that it also may limit the Department of Justice's ability to bring felonies against future defendants, because they've been unequivocal, Vlad. They say there are more people to be arrested and more people to be charged, even though we are more than 41 months since the U.S. Capitol insurrection itself. As the cases have meandered their way through the court system, we've noted a number of the highest level defendants, those names you might recognize, like the Proud Boys or the Oath Keepers, face this charge too, accused of conspiracy or of assaulting police, but also of obstructing an official proceeding. We don't expect those defendants to feel any impact. If you were charged and convicted of a different felony, you're already going to serve a pretty lengthy period of prison. And it's also unlikely, based on my latest reporting, Vlad, that some of those defendants who've already had their cases closed, faced a sentence or faced a plea deal, would try to revisit everything, facing the possibility they may have a plea deal that's less generous this time, may not result in a prison term shortening at all.
All right, you've got your work cut out for you when those prison releases happen. Scott, you've been covering this story, and we appreciate you, man, always. Thank you. All right, let's get into it with former Deputy Assistant Attorney General Tom Dupree. He joins me now to talk about this. So, Tom, you heard Scott's reporting that there is the assumption that some of these January 6 defendants will be let out of jail based on this ruling from the Supreme Court. My question is, what about the cases that are going through the courts right now?
Right. I think the case is going through the courts right now. I think the prosecutors are going to have to reevaluate whether or not the charges are appropriate in each and every case. I think what the prosecutors will need to do is to take a look at the new guidance the Supreme Court has given about the proper, limited, narrower interpretation of the statute and say, is this an appropriate charge in this particular case? I think in some cases they might say, absolutely, we've got the evidence that would support a charge under the new standard. I think in other cases they might say, well, wait a minute, maybe this is a bit of an overreach. We don't have the evidence that fits this new standard, and so we're going to drop that charge. In other cases, they might say, well, as we currently allege it, we don't have the evidence, but we do have some other evidence. We can work into the complaint, modify the challenge or the claim a little bit, and continue on that way. So I think there are a variety of roads here for the prosecutors, but the one thing they are going to have to do is look at each and every case where they brought this charge and make sure that it remains appropriate to do so.
So, Tom, let me just get your analysis of this decision. What did you make of it, and do you agree with the majority?
Sure. Let's see. On the majority, I think the majority did get it right. Look, this is not a surprising decision, particularly in light of the way the Supreme Court has interpreted these types of criminal statutes in the past. They are very interested and focused on giving these statutes a fairly narrow, literal reading, particularly in the criminal context. So from that perspective, it's not a surprise. One surprising aspect of the ruling, though, was the lineup there that we've got on the screen where you see that Justice Barrett was the leader of the dissenters, and you had Justice Ketanji Brown Jackson, who's not exactly a conservative, siding with the majority. So if nothing else, I think this decision does kind of undermine the narrative that's out there that this is a politically driven Supreme Court where people just put on their ideological blinders and vote either with the conservatives or with the liberals. You had some very, very interesting voting alignments in this case today.
All right, Tom Dupree, always great to have you, my friend. Thank you very, very much. Appreciate you. Everyone, thank you. This has been the first week of CBS News 24/7. All these news feeds coming into the CBS News Broadcast Center from our stations and affiliates around the country and, in fact, around the world. This has been a lot of fun. I'm on vacation next week. You're in good hands with my colleague, Lindsay Reiser, but I'll be back the week after that. Stick around. Won't want to miss it.
Coming up, our series. Wait a minute. Tom, is that you working the camera?
Keep leaning out of your close-up.
Your morning routine just got better. CBS Mornings, weekdays at 7.
I had progressively fallen deeper into the world of online sports betting.
The risk is the rush.
What do you think is driving the spike in popularity?
I think it's legality.
If it's legal, I'm going to use it. There are ways to bet when you are 18.
We've created an epidemic of child gambling.
You can't walk into a male dormitory in a college campus without sports betting happening.
It's America's most neglected problem.
I used sports betting as a way to escape, when in reality, I'm choosing self-destruction. Whatever I had left, it was gone.
The purpose of the industry is to get you to play to extinction. And that means until all your money is gone.